if my lawyer is doing a good job? This is a tough question to answer because not only are the answers different for litigators versus transactional attorneys, but even with transactional attorneys, which is what my videos focus on, the definition of a successful outcome is going to vary between specialties and the particularities of your particular case. But let me propose a baseline for what doing a good job would entail. The attorney is competent. The attorney understands and pursues your goals. The attorney foresees potential speed bumps and risks. The attorney meets key deadlines, and the attorney communicates well with you. Now, let me take each of these in turn. First, competence. This doesn't necessarily mean that the attorney needed to have graduated at the top of her class at Harvard Law. It doesn't mean your attorney needs to be a partner either. You can find excellent attorneys who graduated from law schools outside of the top 10 or 20, although I will at least concede that at a certain point, the quality of thinking and reasoning of some of the graduates of lower ranked schools can become a little more inconsistent. And while this is the subject of a future video, I want to be clear that having the title partner doesn't necessarily mean that the person is the best attorney at the firm. In fact, a lot of partners are much better salesmen than they are lawyers, and you'd be better off with someone who is of counsel or a senior associate, whose days are spent doing intensive legal research and writing, not entertaining clients and trying to drum up new business. Ultimately, you want your attorney to be an excellent critical thinker who can express their reasoning clearly through written or verbal communication, ideally both. Some fantastic attorneys are a little more informal, but their logic, preparedness, and clarity of thought should become apparent to you pretty quickly through your email exchanges and telephone calls. The attorney pursues your goals. Now, this can be difficult for attorneys because we're trained to spot every risk and to mitigate it or eliminate it, and to refrain from action until every I is dotted and every T is crossed. This is antithetical to the way most entrepreneurs and business leaders operate. Y'all have a preference for action and a willingness to assume calculated risks for substantial rewards and to make adjustments as you go and grow. It is critical that your attorney understands this dynamic and essentially is able to repress their natural urge to be a series of speed bumps that slows your business down. They need to ask about, and you need to express, your most important short and long-term goals. You also need to be clear about what level of risk and ambiguity you're willing to consciously accept in order to move a deal forward or to make progress on your project. Of course, your attorney will and should wave huge red flags if you propose to do something that is illegal or immoral and will likely result in the two of you in neighboring jail cells or prominently pictured in a damning article on the front page of the local newspaper while your business and reputation goes up in flames. But you might believe that some risk of loss is an acceptable cost of doing business. And if your attorney doesn't understand this inherently, you need to be confident that they've heard you clearly and they can explain to you how the work they're doing addresses risks without compromising your ultimate goals. Your attorney should foresee problems. This is directly tied to competence, but it's also a function of experience. If you've read my free handout, A Dozen Questions to Ask Before You Hire Your Attorney, you'll see that several of the questions are trying, directly or indirectly, to get at the lawyer's experience handling matters similar to yours. The unfortunate fact is that some lawyers will claim they have expertise in your matter when they've actually never handled anything in that area of law before. They sign you on as a client and then they wing it, trying to figure things out as they go along. Now, this is pretty despicable behavior if they're willfully misleading you, but it is more common than you might think. It also makes it impossible for that lawyer to foresee the types of problems that you can only anticipate through years of experience dealing with similar matters, or to have the knowledge to prevent them in advance or to fix them quickly if they arise. This is also why you might want to proceed with a bit more caution with attorneys who are just a year or two out of law school. Now, they're going to be hungry to learn and really ready to prove themselves, and you'll probably get a discounted rate relative to more experienced lawyers. But sometimes you really do need that decade or more of experience to anticipate problems, not just fix them. If your lawyer is asking a bunch of seemingly random questions about nitpicky things, this actually might be a good sign that they're trying to dig deeper and uncover hidden risks. A good lawyer will do this, and a great one will explain why. Meeting key deadlines. Lawyers have a bad habit of promising to turn things back to you within some arbitrary time period, let's say 2 days, unthinkingly, and then they fail to deliver timely because if they had just taken a beat to reflect, they'd realize that their other client demands make anything shorter than, say, a week's turnaround time completely unreasonable. Similarly, clients sometimes call their lawyer in a panic, demanding that something be taken care of within 24 hours, either because they're getting pressure from their vendor or their landlord or their business partner or whomever, or because they're afraid that if they don't create false urgency, the lawyer is going to let their work languish for weeks on end. Let's agree that we all need to stop this crap. A good lawyer will give you an estimate of time, maybe something like, I'll have this to you ideally by Wednesday of next week, and in no event later than the end of business the following Monday. And I'll check in with you on Wednesday afternoon, regardless, to give you a status update if the work isn't totally complete by then. And then the lawyer needs to stick to that. If you have a true hard deadline, you should make its importance crystal clear to the lawyer. This is also why I advise not creating false crises. If you're working with the same lawyer over a long time period, which is what we all want, but you keep crying wolf, your lawyer might not believe he needs to prioritize a true emergency when one eventually does arise. Finally, the lawyer communicates well. Lack of communication is one of the biggest complaints that clients have about their attorneys. What good communication means can vary by industry. For example, I've noticed that my clients in the restaurant industry and in construction and general contracting businesses want to be able to pick up their phone on a whim and speak to their attorney in the exact moment that a question pops into their mind. Some attorneys can accommodate this, but others, mine, my days are structured so that you're going to be getting a legal assistant or voicemail 9 out of 10 times. And then if I try to schedule a meeting, honestly, over half the time, there are no calls, no shows for it. Just as an aside, please don't do this. A lot of attorneys will give you maybe one or two mulligans, but then they're going to start charging you for no call, no shows. Anyway, I can have another video on that that discusses in more detail. The main takeaway today is that even if your lawyer's communication style is a little bit different than what's standard in your own industry, they still need to find a way to figure out how to communicate with you. From day one, they should be transparent about how long you should typically expect to wait for a response to your questions and whether it's better to contact them by email or by phone, and then they should stick to that. You should never feel like you're clueless as to the status of your matter. Ultimately, you deserve to feel like your lawyer treats you and your matter with professionalism, respect, and dignity. If you don't have that, then even if the baseline fundamentals I've discussed today are there, your lawyer really isn't doing as good a job as they should. And one last thing, you are absolutely 100% allowed to consult with another attorney for a second opinion if you're concerned that your current lawyer is doing a bad job. Bear in mind that some of these second opinions will have an incentivization to overinflate the significance of anything that your current lawyer does differently than they would do, since they're going to want to poach you as their own client. But I'm aware that some lawyers insinuate that it would be wrong or impermissible for you to get a second opinion. To the best of my knowledge, that is absolutely false and highly unethical in every jurisdiction in the US. Fellow lawyers, please correct me in the comments if your state has a special rule I'm not aware of, but as a client, your working assumption should be that you can always seek a second opinion. Business owners, in your opinion, what makes a lawyer good and what makes one great?